Right. So I'm Annie Farrakhan, I'm from Southwestern Law School, and it's been great hearing information about the application process and the difference between the JD program and the LLM program. So let's fast forward. You've applied, you've been accepted, you're attending a U.S. law school. Whether you're in the JD program or the LLM program, one of the most basic things that you're going to be introduced to is the concept of legal reasoning or legal decision. And so I thought that it would be helpful to do a mock class that's focused on this very basic concept. Chances are that regardless of the JD program or the LLM program, this is something that you would be introduced to in your legal writing. And the reason I decided to start with this is because it's the foundation to everything that you will do in law school. So whether you're in doctrinal classes, learning criminal law or torts or contract law, or whether you're in skills classes like legal writing, you are going to be doing all your studying and all your performance in terms of assignments or in terms of exams in the context of legal reasoning. And what you're basically doing is kind of predicting how the court will make a decision, how the court will come to a legal decision. And you're doing that because you want to be in a position as an attorney to advise your client, right? You're predicting what the court's going to do. So this concept of legal reasoning or decision making might seem kind of like lofty and overwhelming. But the bottom line of it is that it's not very different than personal reasoning or decision making, which we do all the time in our daily life. And just to kind of illustrate and kind of walk through an example, let's say you are coming to Southwestern Law School. You're visiting Los Angeles for the first time, you're going to be attending this law school, and you need to figure out where you're going to be living. So for example, at Southwestern, we have residences, very nice studios, 1-bedroom apartments, 2-bedroom apartments, 2 minutes walking to the campus. But you also heard about these really nice places to live in downtown Los Angeles. And this is one example with a nice pool and palm trees. And you're trying to make a decision, right? You're trying to go through this reasoning process of which one you pick. So you sit there with your family, and there are some family rules in terms of which one you're going to pick. The family rules are, well, it's got to be a good price. Kind of makes sense. It has to be close to school. It has to have nice security. And we want it to be new and nice. So these are the rules you're operating with. So let's talk about, based on these rules, the pictures that you have of the two possible places that you can live, how do you go about this decision making, this personal reasoning, which one you choose? What do you look at? What other information might you need? Yes. Your neighbors. You want to find out some information about the neighbors because it might relate to security issues. Like, are these nice people, or are they going to be maybe causing some issues, some problems? Good. So you're looking for more facts, right? Anything else that you might be interested in? So specific information about the unit, the apartment. Is there a washer and dryer inside? What does partition look like? Parking? Great, great. So you're looking for more specific facts. We have the basic rules of good price, close to school, security, new and nice, but you want to get more facts to help you make a decision. What about in terms of what do we mean when we say close to school? How does your family define that? Does that mean it needs to be walking distance, or does it mean within 5 kilometers or 10 kilometers, right? It just depends on what is considered as close to school. Same thing with the other ones, in terms of good price. If you are coming from a very, well-to-do background, Vinny's example is a millionaire. If you're Bill Gates, maybe good price is, $5,000 a month, no problem, right? But for most of us, good price means something different. So you have these basic rules, but you have to also have an understanding of what these rules really mean, right? So kind of the comparison is when you're working with the law, you have statutes, you have codes, right? The codes tell you, this is a family code for renting an apartment. The family code for renting an apartment tells you good price, close to school, security, and that. But what exactly that means requires interpretation. And we need to have that interpretation before you can take those rules and apply them to your particular situation, to your particular fact, to make a decision to do that. Right. So let's take this and apply it to an actual legal situation. So the handout that you have, if you go to an exercise in legal reasoning, decision making, starts with a memorandum. So if you're going to U.S. law schools, if you're working in a U.S. legal environment, a lot of the communications are done through memorandums. And this is pretty much what they look like in a formal setting. A lot of the communication now is via email, so it doesn't look as formal as this, but the concept is the same. So this is a memorandum where we're going to work with a hypothetical situation. All right, so this is a memo with the date to the associate attorney, the younger attorney, from the supervising attorney about a client situation. We're going to read through the hypothetical and then kind of figure out how to solve this problem that's presented to us. So actually, maybe just to keep everybody on the same page, I'll read it out loud and you can follow along. Do you have a packet? You have a packet, okay. All right. So our client, Mark Denny, has been charged with first-degree burglary after he allegedly broke into a house on the night of March 27, 2015. So we're dealing with a criminal case, criminal situation. Burglary is basically stealing, right? Mr. Denny told me that he tried to steal the television. He said the house looked empty. He looked through the living room window and spotted a television set that he found hard to resist. Mr. Denny broke in through the front door, entered the living room, and carried out the television set. This is what it looks like. Our client making me get away with the TV set. The house belonged to the Smith family. The family had moved out of the house 2 days before the alleged burglary. All that remained in the house was the TV set, an armchair, several boxes of household items, some chips and soda and paper towels. Cable and phone were disconnected, but water and electricity was still available. The family who had purchased the house was waiting for the purchase closing date, which was a few weeks away. The Smiths planned to visit the home a few times before the closing date to clean the home and move the rest of their belongings. So they're not living in the house anymore. They sold the house, but the sale isn't complete yet. Sam Smith and his daughter Linda had returned to the house to get the rest of their belongings, and they caught Mr. Denny, our client, with the television. Linda, the daughter, was very upset, not only because of catching the intruder, but because her plans to hang out at the house and have some quiet time, Skyping with friends and listening to music were ruined. The prosecution would likely be able to convict Mr. Brady of second-degree burglary. My hope is that we can make a good case that the house was not inhabited, that Lori was living there, and so avoid a first-degree burglary conviction as a harsher sentence. So with this criminal charge of burglary, we have 2 degrees. First degree, if the house is inhabited, people are living there, and that's a higher sentence, or second degree. I need your help analyzing this issue. I've done some initial research on first-degree burglary, and including below summaries of a few cases. I've also attached copies of the relevant statutes, California Penal Code sections 459, 460, and 461. And the last paragraph says that I want you to do a thorough analysis looking at both sides of how strong of a case do we have, because if the prosecution has a strong case against our client for first-degree burglary, I want to know that so I can negotiate. I can pre-bargain for something that's going to be more favorable to our client. So perfect situation of the supervising attorney asking the associate attorney for legal reasoning for predicting how the court is going to rule so that we can best advise our client. Okay, make sense so far? All right, so where do we start? And what's the first thing that we need to look at? We have a basic understanding of the facts. What's the next thing that we need to look at? If you turn the page, the answer is there. So remember going back, when you were trying to make a personal decision, doing personal reasoning, what was guiding your decision making? The family rules, right? In terms of when you're making a decision where to live, the family rules are guiding your decision. In this case, when we're dealing with a burglary, what is guiding your decision is how the court is going to make its decision. And what is the first thing that the court's going to look at? The code, exactly. So you turn the page and you see that California has its criminal laws all under the penal code. Okay? So California Penal Code section 459 says every person who enters any house with intent to commit grand or repeat larceny, steal anything, or any felony is guilty of burglary. And inhabited means currently being used for dwelling purposes, for living purposes, whether occupied or not. The next section of the Code 460 says every burglary of an inhabited dwelling house, so with people living there, is burglary of the first degree. All other kinds of burglary are of the second degree. Why do you think there's this difference between first degree and second degree? And let's look at 461 as well. Burglary in the first degree is punishable by imprisonment in state prison for 2, 4, or 6 years. In the second degree, imprisonment in county jail not exceeding 1 year. So if the criminal is your client, what do you want to do? First degree or second degree? Second, right? So very obvious. Why the difference though? Why is the sentence, why is the punishment so much higher for first degree? Yes?
I guess with the first degree, you have to went into someone's place and coming out. Or whereas the other case, maybe you could be someone else's residence, getting into someone else's property.
So in both cases, you're entering into somebody's property. With the first degree, there's that requirement that the property be inhabited. So there's somebody living there, even if they weren't home at the time. So why do we want to punish that more strictly? Right. So let's say, the house has been sold, nobody's living in it, the current owners are out, the new owners are not yet in, there's nobody occupying the house. So if somebody goes in to steal something, you don't have that threat to human life, right? So that's why a huge difference in terms of the punishment. The 1 year in county jail versus 2 or 4 or 6 years in state prison. That's why the difference. So burglary, is our client going to be guilty of burglary to some degree? Probably. There isn't probably much that we can do to help our client with that respect. Under Section 459, every person who enters any house with intent to commit grand or complete larceny. Yeah, this guy entered, took the TV, was running out with the TV, right? But then the issue is first degree, long sentence, or second degree, short sentence. Well, it depends on what? Whether the house was inhabited under the statute, right? Does the statute tell us very much? Section 459 says inhabited means currently being used for dwelling purposes, whether occupied or not. Is that very helpful? Not very helpful. So we're kind of in the same situation as the family rules, good price, close to school, security, new and nice, but what do those exactly mean, right? The good price to Bill Gates means $5,000, $10,000. To me, it means $1,000, maybe $1,200, right? So it all depends. So we need to figure out what constitutes inhabited. So how are we going to figure that out? Can the judge just kind of say, that's whatever I want it to be? How do we figure out what inhabited is? Yes?
Can be decided whether the Smith family obviously has the other house used as a home. Where the house was using the
Because the Smith family had already moved out, they're not living there anymore, so they're just getting their stuff out, so it's not inhabited. Okay, that's a very good argument, very good point, and it's based on your common sense, right? Is the court, is the judge going to be making a decision based on her or his common sense or something else? What if the judge is in a bad mood or just has bad common sense? So that's why what the court is bound by is the concept of precedent. So cases that have come before the court in the past that have involved this question of what does inhabited mean, how has the court interpreted that? How has the court explained it? And so that's called the concept of precedent. Decisions that have been made before that are now going to be applicable in this case. And that's what the court is bound by, and that's what you need to look at as attorneys to then predict how the court's going to interpret these facts. And so if we turn the page to see summary of case law. And so we will be looking at court decisions under these penal code sections to find cases that have interpreted the concept of inhabited. And this is what we have, right, with the Smith home inhabited. Here we have Linda, who wants to be, FaceTiming, Skyping with friends and listening to music. Mr. Smith, who's there to move some boxes. And the only stuff that's left, in the house is the TV that was stolen, an armchair, some soda, potato chips, and some paper towels, right? Well, let's look at what the precedent says in terms of what inhabited means. So regardless of the defendant's impression about whether a house is inhabited, so regardless of what our client thought, the court will determine that the house is inhabited based on the views of the person with the possessory right. So it's what Mr. Smith thought in terms of, whether we're still living in this house using it for good purposes. Protecting against danger to personal safety is behind burglary laws, including the danger that the intruder will harm the occupants in attempting to perpetrate the intended crime or to escape, and danger that the occupants will in anger or panic act violently to the invasion, thereby inviting more violence. And that's the point exactly that we make in terms of that's why it's a heightened sentence for the first degree burglary. So a structure that's being used as a temporary home or a place of rest at the time of burglary is inhabited. A reasonable person would expect some protection from unauthorized intrusion. In one case, the court found that a hotel room, just a hotel room, rented for one night by a man to party with a woman and spend the night there, constituted a temporary place to live and inhabit it, even if not the victim's primary house. The court explained that people have an expectation of freedom from unwarranted intrusions into a room in which they intend to store their belongings, sleep, dress, bathe, and engage in other intimate personal activities. So it doesn't matter if it's a temporary place that you're staying. If you have those expectations, it's inhabited. However, if the occupants have moved out of a structure permanently and don't intend to return to use the structure as a home, the structure is not inhabited. For example, in that case, the court decided that a house that was only being used to store belongings after the occupants had moved to another house was not inhabited. So here we have a situation of, yes, storing belongings. So that if that's all that was going on, the house would not be inhabited. But you also have these other stuff. You also have Linda, who wants to use it as a place to chat with friends and listen to music. So how do you go through that real reasoning? How do you think the court is going to rule? And there's no right answer or wrong answer. The way I've made the facts, you can argue this side, and you can argue that side. And at the end of the day, it's probably pretty balanced, right? Can you think of arguments that would help our client that the house was not inhabited? What point would you make to your supervising attorney that the house was not inhabited? What would you emphasize? What would you focus on?
I'm not her age. Usually children doing what they want to do. So, and also the stuff owned after unsure, and the other thing is kind of fresh. So I want to call them out to show that it's not kind of.
Yeah, very good point. Very good argument. Well done.
According to this email, from Supervisor Attorney, that since trying to visit the home for the looking clean the home. That means also, even at home, that means the house itself is in the middle of process of turning new kind of part. All the items left in the house are not centered to living. Doesn't mention about refrigerator food, phones, all household items, so that which can be found anywhere. None of them is
Right? Fantastic argument. Very good. So I think the point that each of you made, putting them together, makes a very, very good case, very good argument for the defense. Really well done. Now, what you have to think about is what are the best arguments that the other side is going to make? What are the best arguments that the prosecution is going to make? Because you have to do the legal reasoning from both sides to be able to best advise your client. So who wants to wear the prosecution's hat and argue that the house was inhabited? Yes.
We don't use work cases as a not for doors. They tend to be within, certain days. So that means we were inhabited in that home.
It's food around the house.
I mean, soda, you could wear it for years, but not use it.
Yeah. And so build on that. What's the story that you can start building around the potato chips, the soda?
The dry soda, they left problem set an armchair and people house. Maybe Linda was trying to invite some friends over to have a little gathering. For entertainment.
Yeah, very
So
good.
they really acting loud.
And tell me a little bit more about Linda's plan.
So that it's trying to talk to their friends.
Yeah.
So that
Yeah. So these are all things that you would do in your home, in a protected area where you think you're going to be free of intrusion. Absolutely. Very good points by our prosecutor here. You guys better watch out. Really nice. Anybody else want to add on to the prosecutor's point? Yes. And it goes back exactly to the point that you raised before, why we want to protect inhabited homes more than uninhabited ones, because if Linda is sitting back, just listening to her music, Skyping with friends, Dad is doing his thing, and somebody breaks in, there is that potential of violence, right? Because they feel like this is their home, they have a right to be here, they're not expecting any kind of intrusion. Very good points by another prosecutor. So just a really good illustration that typically legal problems are not a slam dunk. It's a very, very, very rare situation where it's clear cut that this side is going to win or that side is going to win. So there are always good arguments to be made for both sides, and that's why lawyers stay in business. And there's always representation to be done and points to be made. So really good exercise, really nice points that you guys made, and that's what you go through. So in terms of legal reasoning, decision making, if you're going to be communicating your reasoning in writing, which is technically the way, before you sit down to write your analysis, these are the steps that you go through. You identify what the issue is and what was the issue in our situation. Inhabited or not, for purpose of burglary, exactly. What are the significant facts? You have the significant facts from the memo, exactly the ones that you were pointing out. Good for the defendant, bad for the defendant. You have to be laying it all out. What law applies? We have the code sections that apply, and then the interpretation of those code sections, which is the precedent, because that's what the court has to follow, which is different from the civil code system, right? So the civil code system, primarily what the court looks at is just the codes. But under the American jurisprudence, they have to look at the interpretation, the common law that's been developed. So those precedents have to be consulted. And then what you do is you take the law and apply it to your facts, which is exactly what you were doing just now. You do objective analysis, looking at one side, looking at the other side, kind of figure out which one is going to come out a little ahead. And then when you go to the court, obviously you're making persuasive arguments, taking the side that's going to best serve your client, right? So you go through that whole process, and then in your writing, whether it's for a law school exam, whether it's a legal writing course assignment, or at your work, at your job as a lawyer, this is typically the organization that you use. How many of you have heard about IRAC? So, if you've studied law, it's a very familiar concept. So anytime you're communicating legal reasoning, it's expected that you're going to do it in the form of first identifying the issue, one sentence, then the rules, which could be a paragraph or two paragraphs, then application or analysis, taking those rules, applying it to your facts, which was the conversation we were having here back and forth. That's a few paragraphs of application. And then your conclusion. The court is likely to find the home was inhabited. The court is likely to find the home was not inhabited, whatever your conclusion is. So issue, conclusion, one sentence, the meat, the bulk of your analysis, your writing, comes in the middle. And we've taken about half an hour, and what you've gone through is basically the concept of legal writing and analysis that all JU students and all L1 students go through. And wonderful participation. Thank you for being so great.
Staring out the window, I can see the wind blow. Watching my